Good afternoon, everyone. My name is Tom McTigue. I'll be presenting my Keystone project today, the title of which is The Dangers of Ambiguity in Patent Law, the Impact of Section 33 of the American Invents Act on the Science Field, and Analysis of the Appropriate Response. My advisor for this project was Professor Paul Guglielza from the BU School of Law. I'm very thankful for his help and his guidance throughout the project. Before getting actually into the meat of the project itself, I thought it'd be nice to give an overview so you have a general sense of where we're going with it. Of course, I'll give you an introduction to Section 33 because you probably don't know what it was. I didn't before. And then how Section 33 fits into our larger theme of the restrictive stance taken towards science patentability, how this impact could be augmented by the current vulnerability of the science field in terms of funding, and then go with my project aims, design, and then the data actually collected. So, Section 33 of the Leahy-Smith American Invents Act states, notwithstanding any other provision of law, no patent may issue on a claim directed to or encompassing a human organism. The terms in bold have purposely been bolded because they are left undefined when it was passed by Congress for future interpretation by both the Supreme Court and the USPTO, which stands for the United States Patent and Trademark Office. However, in the meantime, there is now uncertainty and ambiguity related to the patentability of scientific claims. I think this gray area is really portrayed well in two examples. The first was a catheter itself is patent eligible, but it was denied a patent grant in 2012 after the passing of Section 33 because it was used in conjunction with the human embryo. But some researchers are able to circumvent this little gray area, and that was in the case of studying Alzheimer's plaques in monkeys. They were studying a human disease in a non-human animal, and they were actually able to receive a patent grant for that. So there's a little bit of ambiguity related to this. And then, as I said, Section 33 fits into our larger theme, which is the restrictive stance taken towards science patentability, both by Congress and by the Supreme Court. This started in 1995 with the defunding of the Office of Technology Assessment, the OTA. The OTA was defunded because Congress said that they were merely creating redundant work, and the redundant work they were doing was providing Congress with objective data and analysis about scientific problems that are caused or could be helped by congressional measures. After that, in 2004, there was the passing of the Walden Amendment, which was headed by Representative Walden there. And in this amendment, he said no funds of the appropriations bill as passed in may be used towards patenting anything directed to or encompassing a human organism, which is the same language adopted by Section 33 of the American Invents Act, which was signed into law by President Obama in 2011, except that this time it's now directly related to the USPTO in terms of issuing patents. And then the Supreme Court has now carried this restrictive stance itself in two decisions recently, the first being in 2012 with Mayo Collaborative Services versus Prometheus Laboratories. Prometheus Laboratories was suing Mayo Collaborative Services over patent rights related to determining the metabolic threshold of thiopurine drugs in autoimmune diseases. The Supreme Court ruled that this threshold itself is just a natural occurring law that they were detecting, so it is therefore patent ineligible, and they actually reaffirmed this belief in the case of Association for Molecular Pathology versus Myriad Genetics in 2013, in which Myriad Genetics found the exact location of the BRCA1 and BRCA2 genes, which are correlated with higher risks of both breast and ovarian cancer, and they are using it in their own kits, the Association for Molecular Pathology, and the Supreme Court ruled once again that this was patent ineligible because it's simply a gene which is naturally reoccurring. So, this general stance of restrictive science patentability can actually have a larger impact on the science field because the science field is currently vulnerable in terms of funding. So the two main sources of funding are both public funding through governmental organizations such as the National Institutes of Health, NIH, the National Science Foundation, NSF, and if you can see in this first graph here, the top bolded line is the actual dollar amounts of NIH funding approved by Congress, and then the dotted line is the inflation adjusted. And as you can see, with inflation adjusted, it's been decreasing steadily. And then that red line on both of them is actually when the sequestration happened in 2013, in which Congress cut their budget by $1.5 billion, or 5%. And then this actually did have a direct impact in terms of NIH grants that were funded. So they hit about a peak of 33% funded in the early 2000s. And then after the sequestration in red, it decreased by over half to 15%. So this shifts the need for funding onto private investors or private funding, which of course is dependent on the return on investment, which is dependent on profitable patents, which incentivize research. So now the science field is very vulnerable because most of the dependence is now on private funding. So in terms of my project aims, the first, of course, is to assess the impact of Section 33, and especially its impact on the science community, then determine whether a legislative response is warranted if there was an impact, and then to see if there's a disconnect between the scientific and legal communities by comparing their opinions on Section 33 through a survey. So the project design started out with a literature review in terms of how to actually get quantitative data to show the impact of Section 33, and most of them are doing it based on the number of patent grants patented. And I gathered these data resources from the USPTO, and then for the survey I was going to administer, I needed to get IRB approval. And then to actually see what the impact was, I compared the number of patent grants in classes, which the USPTO just deems by common features, in a 3-year interval before the passing of the American Invents Act to a 3-year interval after, to see if there was a significant decrease using a 2-proportion z-test. And I took 2 patent classes that did have a significant decrease, and I examined those at the subclass level, just because it'd be a little bit more specific. The subclass provides shared processes within the class level. And then from that, I administered that to the science and legal communities here at BU through a survey to see what their opinions were on it, and also see if I could influence opinions after presenting data. And this actually gets me into the patent data at the class level. So this little table shows you that about 40% of the total classes, which are the 470 of them, decreased, 50% increased, and 9% no change. This shows you that there isn't a general decrease over the board of all classes. However, what I was most interested in were the 2 classes that experienced the most significant change were related to science, and that was medical and laboratory equipment, class D24, and class 530, chemistry, natural resins, or their derivatives. And then I examined that at the subclass level, and although these classes don't seem related in terms of their title, as I said, the subclass level is more specific, and when examining at the subclass level, it was found out that the subclass levels that experienced the most significant decrease were all related to medical treatment and diagnostics. And then bringing that back to what I was discussing earlier about the vulnerability of the science field, you have medical treatment and diagnostic research, which of course can be funded through public means. And then, as I said, the NIH funding's been cut in terms of inflation. They're not increasing it enough to keep up with it. And then sequestration, so you have that cut off. And then I said private investors are dependent on the profitability of a patent and the likelihood of getting that. And because of this restrictive stance taken towards the science community in terms of patentability of their claims, the likelihood has decreased as well, which has therefore decreased the chances of private investors, basically cutting off the funding of the scientific research. And medical treatment and diagnostic research can fit into other fields, such as medical treatment optimization to make it cheaper, personalized medicine, which is becoming a huge industry in itself, and then drug discovery, all of which will be impacted by this. In addition to the quantitative data, I also administered a survey. There were 7 questions. I didn't have time to go over everyone today, so I decided to go over this one. This question was asked twice during the survey, both before presenting quantitative data and after. There are 3 answers. The statute's acceptable, it should be amended or should be repealed. I'm only focusing on the fact that the statute should be amended. And as you can see before the data, there was less percentage of the total respondents that thought the statute should be amended. And after presenting them with my quantitative data showing the impact of Section 33, it increased both for the science participants in blue and the legal participants in yellow, which shows that my contextualization of the impact of Section 33 actually influenced people to change their opinion on it, and that they thought there should be a legislative response. And then going over my 3rd project aim, which was to compare the scientific and legal community's opinions on Section 33, there actually was a general consensus. They had similar opinions regarding the statute before the data was presented. They had 56% of them both thought the statute was acceptable. And then interesting enough, both of them thought there should be a legislative response if there was a decrease in the number of patents related to a human organism. And then going off the graph I previously showed you in terms of people that thought it should be amended, 77% of the participants who thought the statute should be amended suggested clarifying the language of the statute, which of course shows that the statute's harmful because of its ambiguity and uncertainty. So conclusion and future directions. Overall, there was a decrease in the number of patents related to medical treatment and diagnostics after the passing of the American Invents Act. It should be noted, of course, there are potential confounding variables, including the decreased funding overall through the public sphere, and then the Supreme Court's heightened restrictions on the patentability. I think these personally all fit together in a larger theme, and that may have driven my results. It might not just be Section 33 itself. And then what I think is actually very interesting is that when I contextualized the impact of Section 33, it was actually able to alter some people's opinions on the statute. And this could show, even though the OTA was defunded in 1995, there should be a similar organization today, or maybe a similar research that could help contextualize these problems affecting the science community that Congress has passed. And then my last one is that this general trend of the restriction of science patentability is having an impact on the science field, and the Supreme Court now has the opportunity to actually loosen these restrictions. In the case of Ariosa Diagnostics versus Quantum Inc., in this case, one company was able to find fetal DNA in blood in a novel way, but they're using very conventional means. So the Supreme Court, in this decision, should be able to reverse the dangerous precedent that's been set in the past and actually help reverse this restrictive stance taken towards science patentability. Thank you for your time and any questions. Yes.
So what do you think of Section 33? Should it be amended? Should it be repealed? What do you think?
I personally, so based on what I've found was that I think it personally should be amended, just in terms of its language. I don't know if this amendment should be made exactly to the statute itself, or it should be more of what Representative Walden did himself. So after the passing of the Walden Amendment in 2004, he actually gave a speech before Congress saying that his statute was basically trying to protect scientific research on human embryos, which is a long-standing tradition of the USPTO. He said this shouldn't even affect stem cell research, which was very controversial at the time. So I think if someone actually came out and said what the target was of this statute, I think it would be better. If it was standing with tradition, in terms of what the USPTO has always believed, no scientific research on human embryos, I think they should clarify it like that. In the meantime, people are having issues, and I don't think the USPTO should be interpreting it themselves. It should be either the Supreme Court interpreting it or Congress coming up with a new statute.
I don't know if you know the justices' past opinions on these cases specifically, but for the current breakdown of the Supreme Court, do you think it's likely that they'll change the precedent, or do you think based on the justices' past opinions that they're more likely to keep the status quo with whatever the decision is?
That's a pretty good question. So actually in the two decisions prior to that, the first one was I think a 5-4 decision, the other one is unanimous. So based on that, I think they're most likely probably going to stay with the status quo, even though I would like them to go the other way.
Do you, or in your research, did you run into any issues where perhaps the Supreme Court does not have the scientific background in making the decisions?
Most of my research was more data-based. My general opinion is that I did think there was kind of science illiteracy between the scientific and legal community. But based on the survey, the legal community did understand the statutes and potential impact on the scientific community. So I think that speaks less to the distinction between the scientific and legal communities at large, and more maybe to the science literacy of Congress as a whole, especially in things like global climate change, where they come in with a snowball and just drop it on the ground and say, like, global climate change isn't a thing. I think you can't be having people making these very important decisions have those beliefs.
So for like your background, your like hard science background, going into like a law field, what do you think like you'll bring to the table, and how like do you think there'll be a new like generation of lawyers who actually communicate about these topics that we understand now, or do you think that like we need more lawyers like you who have this hard science background?
I think it'd be nice to say we need more lawyers like me. I'm not actually a lawyer yet, but after law school, yeah, no. I think with my scientific background, I was more leaning towards patent law, so that's why I have such an interest in this. I think in general in the public, there's a new change on being able to interpret data. So the new SAT is now actually based on being able to judge quantitative data and the analysis associated with that. So I think you don't have to have a hard science background, but you should be able to appreciate results and know how to interpret them. All right. Thank you for your time.